national thought leader on constitutional law and the United States Supreme Court. Josh's work was quoted during 2 presidential impeachment trials.
Back to back. Probably a third coming soon.
Back to back. He's going for the 3Ps. Josh's work was quoted during 2 presidential impeachment trials.
Yeah.
He has testified before Congress and advises federal and state lawmakers. Josh regularly appears on TV, including NBC, CBS, ABC, Fox, and the BBC. Josh is also a frequent guest on NPR and other syndicated radio programs. He has published commentaries in the New York Times, Wall Street Journal, Washington Post, and leading national publications. Since 2012, Josh has served as a professor at the South Texas College of Law in Houston.
EJU, as you call it.
He holds the Centennial Chair of Constitutional Law. Josh is the senior editor of the Heritage Guide to the Constitution, 3rd edition. Josh has written more than 7 dozen law review articles that have been cited more than 1,000 times. Josh was selected as the Jurist of the Year by the Texas Journal of Law and Public Policy, received the inaugural Mies the Third Originalism Award. Did I say that right?
Close enough.
Okay, Mies III, from the Heritage Foundation, and was awarded the inaugural Joseph Story Award. Josh was selected by Forbes magazine for the 30 Under 30 in Law and Policy. Josh is the president of the Harlan Institute and founded Fantasy SCOTUS, the internet's premier Supreme Court fantasy league.
But I graduated law school before 2015, so I'm old.
You said it, not me.
That's true. That's good.
All right.
Good?
Well,
Good.
Thank you.
All right. Have the mic?
Well, that is you.
Thank you so much. That was a fun introduction. I was last in this room in 2019. My little Miriam was barely a year old, and now she's turning 7. So it's been too long. Thank you to Elliot and Charbel, everyone else, for having me. The topic today was advertised as Trump's first 100 days, but we're actually further along. Tomorrow will be 150 days, basically 5 months since Trump was inaugurated. And there is a lot to cover in very little time, so we will move with speed. And I'll try to divide Trump world into 5 categories of cases. The first is removal of officers. The second is birthright citizenship. The third is the Alien Enemies Act, which no one ever heard of before this. The fourth is doge, spending cuts. And the fourth is firing of civil servants. So the first category of cases is actually the most significant. A lot of the things Trump is doing seem important now, but probably won't matter a couple of years ago. But there has been a 9-decade-long struggle, 9 decades between Congress and the presidency, about the so-called removal power. Most people believe that under the Constitution, the president has the power to remove officers. He can appoint them with the consent of the Congress, but the Constitution is silent how you fire them. So from the very beginning, George Washington and others assumed that, of course, the president can fire people. There was a decision from the 1920s called Myers against the United States, where Congress tried to say, you can't fire a postmaster. And the president said, I'm going to fire him anyway. And the Supreme Court approved, saying, this is true, the president's power removal is absolute. But then barely a decade later, we had a case called Humphrey's Executor. This was decided during the height of the New Deal. And Roosevelt tried to remove a member of the Federal Trade Commission, poor William Humphrey. Now, why is it called Humphrey's Executor? He actually died while the case was pending. I often joke that Roosevelt probably had him murdered. It didn't happen. True story. I once said this in class. I said, I bet Roosevelt had him assassinated. And someone actually got a death certificate. He died of a heart attack. So it's not a thing. Foul play. But in Humphrey's Executor, the court held that Congress can protect or insulate from removal members of so-called independent agencies. See these scare quotes? The idea of an independent agency is kind of like an oxymoron, right? In our government, we have 3 branches, and there are 3 branches. If you're an executive officer, you're under the president. But Congress said we need these expert agencies to make policy and to make rules, and has to be protected from the president himself. FDR tried to fire poor Mr. Humphrey. The court said, no, you cannot fire him. Well, of course, he was dead, so he was out of office. But the precedent was set forward. Jump to the 1980s of a case called Morrison against Olson. A very famous case involving independent counsel. This was what Ken Starr was, right? Remember Ken Starr? The investigation of President Clinton. People born with 2015 graduations don't know who Ken Starr is. But if you were alive in the 90s, you know what Ken Starr is. So the Supreme Court upheld this independent counsel who the president could not fire. They said, well, look, Congress has the power to protect these officials from removal. So since the 1980s, FEDSOC has said consistently, overrule Humphreys. But no one's willing to test it. Not Reagan, not Bush, not the other Bush, not Trump 1.0. But Trump 2.0 came in at the gate and said, we're gonna test Humphreys. How? He fired everyone. Right? He fired members of, I'll get these wrong, the FTC, the MSPB, the EEOC, and all these alphabets. I can't remember all these. He basically fired all these independent commissioners and said, sue me. And they did. This went through the courts, and there was a decision on this not even about a month ago, in a case called Wilcox, W-I-L-C-O-X, Wilcox. She was a member of the National Labor Relations Board. This case came to the court on the so-called emergency docket, which we hear, this nefarious shadow docket, right? It's actually not that evil. This is how judges decide cases under emergency. So, judges in this room, do you all have emergency dockets in your court? Yes, if there's a capital case, something emergency, you get a phone call at 2 o'clock in the morning. Every court has an emergency docket. This is just how all judges operate. So the case comes to the court, and the court splits. And the court says that Trump may have the power to remove, may not. But what's important for now is the status quo, is they say, Ms. Wilcox, you're out of the job. The court punted. The court said, we will decide this next term, but for now, you're out of your job. This was a ground-shaking ruling, and it was narrow. The court didn't really say whether Humphrey was right or wrong. All they said is, this job seems like an executive position, and the president can fire executive officials, and that's all we're going to say now. There's basically a sentence or two of actual analysis. So this will be a case teed up for next year. Again, whatever Trump does, if he actually succeeds in getting Humphrey's executive rule, this will be a milestone. This will vindicate Justice Scalia's dissent in Morrison versus Olson. This will be sort of a transformative decision. As a practical matter, it won't make much of a difference, right? Generally, you have these commissions who do what the president more or less wants, and if he can remove people when he comes to the office, you have the agencies consistent with the president's agenda. I don't think people even notice if it's overruled. People won't even care. Okay, so that's the first category of cases I want to talk about. The second category concerns birthright citizenship. This is an issue that's been sort of lingering for almost 150 years, only slightly exaggerating. The 14th Amendment was ratified in 1868, and it begins, all persons born or naturalized in the United States are citizens of the United States. Then there's this other phrase that people always skip over. As long as they are subject to the jurisdiction thereof. So if you're born here, you're a citizen, so long as you're subject to our jurisdiction. What does that language mean? And truly, for 150 years, there's been a debate on this issue. It's not like new. There's one school of thought that says, subject to our jurisdiction just means are you subject to our laws? If you're here and you're an alien, can you murder? No. Can you, run a red light? No. Do you have to follow the law? Yeah. Okay, you're subject to our jurisdiction. The second analysis considers that subject to the jurisdiction means loyalty or perhaps allegiance. In other words, are your parents subject to our loyalty, our allegiance? Or are you here illegally, inconsistent with our laws? Why does this matter? On day number 1 of the administration, President Trump issues an executive order saying that going forward, we, the federal government, will not issue any documents, a passport, for example, to the children of illegal aliens. So Trump, again, like him or not like him, he's testing precedent. He's trying to have a test case engineered to decide whether there is birthright citizenship under the Constitution. Now you're saying, Josh, hasn't the Supreme Court decided this issue? Not really. There was a case from the 1890s called Wong Kim Ark. Wong Kim Ark. And this case concerned the child of what we would now call a resident alien, basically a green card. That wasn't called a green card then, but imagine the children of a green card holder. If you have a green card, you're here under a legal status. You're not a citizen, but you're subject to our laws. So The Wong Kim Ark case doesn't really speak to this issue. Now, it's true, and I've written this before, for over about 100 years, the government has assumed we have birthright citizenship. Trump is saying, I want to try something else. All right, so within hours of Trump's order being signed, I'm not exaggerating, federal judges issued universal injunctions against it. Now, I just want to ask the judge in this room, before you grant a TRO, do you actually read the briefs? I'm being 100% serious. There's one judge in Boston, Judge Burroughs. I'm not joking. Harvard University sought a TRO. She granted it within about an hour or two. There was a 70-page brief and 200 pages of exhibits. I've done the math. Speed reading. No. Yeah, ChatGPT. There is no way that either she or her clerks read it. And I have a problem with judges granting ex parte TROs without ever reading the papers. That's malpractice. Any of you judges signed a TRO without reading the papers, you'd probably be removed from the bench. But we're in a world now where judges, remember like when you're a kid, you have a little hammer in the knee and your knee goes up? That's like TROs. You just kind of hit the knee and the TRO comes out. It's reflexive. There's no thought involved, right? It just happens. It's like, oh God, blank versus Trump, TRO grant. And that's sort of where we are. It doesn't even matter. And they just sign the order. They grant whatever relief is requested. They don't limit relief to the parties. They don't consider the hardship to the government. They just grant it. So as going back to the issue with the birthright citizenship, literally within hours, judges granted national injunctions. But there's a problem, a lot of problems. The plaintiffs in these cases were blue states, Maryland and Washington, Oregon, other states, and various groups representing immigrants. But Florida didn't sue, and Texas didn't sue. What business does a court have in granting relief to non-party states? The answer is they don't. Right? There has been a debate about national injunctions for going on a decade. I was writing about this in 2014, so we're talking 10 years. This is a decade-long debate. But these judges said universal injunction that if you're born anywhere from sea to shining sea and Hawaii, and Alaska, right? You are a natural-born citizen, even though Texas, Florida, Alabama, Mississippi, all the sort of SEC states, right? Those states did not bring lawsuits. So again, all the lower courts ruled against Trump, reflexively, and the case went to the Supreme Court. The court heard oral arguments on May 1st, so just about a month and a half ago. Curiously, Trump made a decision. Well, not Trump, but his lawyers made a decision, a strategic decision. They didn't ask the Supreme Court to decide the question of birthright citizenship. They didn't ask them to resolve the constitutional question. The only question they said is, can you limit the injunction to the plaintiffs, to the parties? So again, no one from Texas brought a lawsuit. Don't extend this ruling to Texas. Same for Florida. The Supreme Court's in a tough spot, right? Because the obvious answer is you can't do that. It's so obvious. Any 1L civil procedure student knows this. If you graduated in 2015, you know this. Right? It's obvious. But if the court goes this way, aliens born in roughly half the states will not be citizens at birth. So this is kind of a Rorschach test, kind of a moment of what will the court do when the legal principles obviously go in one way, but the heart, tugging the heartstrings, goes the other way. I don't know what they'll do. We'll get a ruling, the 19th? About a week from now, so I can duck it for now. But within the next week, we'll get a decision. I think it can be done by about the 30th or so, depending how the calendar winds down. It's about 10 days. We're almost done. They decided 5 cases yesterday. We'll have our opinions handed out tomorrow morning. They usually do it on Thursday, but happy Juneteenth, everyone. It is Juneteenth. Do you know what Juneteenth is? You don't even know. Juneteenth was the day that the slaves in Galveston learned the Emancipation Proclamation. It's actually it's a good holiday, but it's in the middle of the week, so the court didn't issue decisions on Thursday, they did on Wednesday. All right, that's category number 2 of cases. Category number 3 concerns the Alien Enemies Act of 1788. Yes, that's correct. We are talking about a statute passed by the John Adams administration. You've all heard of the Alien Sedition Act, right? People know about the other part, the Sedition Act. What they don't realize is the Alien Act is actually still good law, right? It was never repealed. Sedition Acts don't exist anymore. Alien does. And the statute, I'm just going to sort of summarize it grossly, says, if you are an alien enemy, you can be removed, period. no habeas, no TRO, no judicial review, adios, right? This was used to remove people during the Adams administration. In my mind, this is actually suspension of the writ of habeas corpus. This is if you're an alien enemy, you're out. So what is an alien enemy? So the easy example is if we've declared war against a country, Germany, Japan, Italy, World War II, you're an enemy alien. No one disagrees about that. If you imagine the bombers at Pearl Harbor, right? They were an invading force. If any of them had crash landed in Hawaii, well, what would we do? Well, you couldn't really send it back to Japan, right? Because we were at war with them. So what you usually do, you detain them. So people don't realize this, but Korematsu, the case, was based on the Alien Enemies Act. If you were a U.S. citizen, it was a different story. But if you were a Japanese national and you were in the United States, you were detained under the authority of the Alien Enemies Act. Why? Because we can't deport you to Japan. We're literally at war with this nation. So this statute's been used for many years. And the traditional rule has been the courts don't second guess invocations of the Alien Enemies Act. This is just an area where the courts grant almost slavish deference. But Trump. So what happened? On the day number one, President Trump declares an invasion. Who's invading the United States? Tren de Aragua. It's a Venezuelan transnational gang. And President Trump tried to remove a fairly small number of people, I think it was under 200 people, who were alleged to have been members of this gang, and send them back. But wait a minute, you can't send them to Venezuela. That's a country we're having a conflict with. So instead, he sent them, or tried to send them, to a prison in El Salvador, the CITAT. It's an acronym, I can't remember. But it's a high-security prison in El Salvador. This is a case that there's lightning outside. Maybe I'll have the righteous indignation. This case makes me really angry. So, pop quiz for Civpro. Habeas. Which court has jurisdiction over habeas proceeding? Where do you bring a habeas action? Where the body. Yeah. Habeas corpus, bring the body, right? Because the custodian, right? Where is the custodian being held? So Trump is no fool. He kept all these people in Texas, right? And Louisiana. Yet, amazingly, when he was trying to remove these aliens, a judge in the District of Columbia, which is, the Amtrak does not go down to Texas. We don't have the cell of the corridor is not that wide. A judge in D.C., his name is Judge Boasberg, he's kind of like 6'7", he's a big guy, asserted jurisdiction. And if you actually read the transcript, it's insane. On a Saturday afternoon, he held a TRO hearing. He was basically in his pajamas, I'm only exaggerating slightly. He was on his beach resort, right? And the plaintiffs brought was effectively a class action habeas case, saying we are trying to certify a class of unknown people who might be removed from this country. You can't do that. There's no such thing as a class action habeas. We don't even know who the pre-talker. That's not a thing. You can't do that. And so the judge, this is remarkable. The judge said, "Yeah, I don't think you can bring a habeas because I don't think I have jurisdiction because the custody's in Texas. Why don't you bring an APA action, Administrative Procedure Act?" The judge told the lawyers of the ACLU to replead their case. Whose team is he on? You don't do that. It's not a pro se litigant. It's the ACLU. And it said, "Okay, Your Honor, yeah, we'll do that." He said, "Okay, good. Okay, now that you've done that, I'm going to grant a provisional class. Not sure who these people are. I'm going to grant the ex parte TRO, and DOJ, you turn those planes around. If there are planes in the sky, you bring them back." He has no idea what the hell he's doing. There are flight plans. There are arrangements with foreign countries with their airspace. There are fuel restrictions. You can't just stop things. That's not how the law works. And then he issued another order. Turn the planes around. And he asked the DOJ lawyer, "Where are the planes?" The lawyer's like, "I don't really know, sir. I'm in D.C. I have no idea. DHS is running this." I'll come back to that later, but just want to mention this point. Sometime later, Judge Boasberg actually tried to hold the lawyers in contempt. He wanted to hold the U.S. Attorney General in contempt for not complying with his orders. Thank the Lord that a good panel of the D.C. Circuit, not many, put that on hold. Judge Rao and Judge Katsas, thank the Lord. But this went on for some time. They did another case, our favorite Maryland father, Kilmar Abrego Garcia. Remember him? Yeah. So he was one of the people who was removed, and the government admitted it was a mistake. Not that he shouldn't have been removed. He should have been removed, but there was a court order saying he shouldn't be removed. So the government made a mistake. They said, we can't bring him back. Why? He's in El Salvadorian prison. So a federal judge in Maryland ordered, bring him back. He's in the custody of a foreign nation. And she said, President Trump, you go ask him. You can't tell the president what to do. There's no ordering against the president. He's a coordinate branch of government. And then the Fourth Circuit affirmed, saying, bring the guy back. The Supreme Court, though, kind of again punts. The Supreme Court says, well, government facilitate its return. That's where it is, facilitate. That's a good lawsuit. Good legally word, like facilitate. And then the judge started having all these conferences saying, where is he? I'm like, well, we're working on it. So not even about 2 weeks ago, I was actually in D.C. when it happened. We brought him back, but not how he wanted to. He was indicted on charges of human trafficking. This guy is on camera driving a modified SUV in Nashville, where he basically added another row of seats that even more aliens in the back of his car. That's like a third row of seats. He was trafficking people into this country from Mexico, lying to officials that, oh, we're just going to a construction job. That's what he said. No, he was bringing him up from the border. Oh, we're going to St. Louis. Yeah, St. Louis. We're from Texas. Yeah, he was making $100,000 a year trafficking people. Some children, women also. So he is currently sitting in a holding cell in Nashville. So the government facilitates return, and should he ever be convicted, he will serve time in American prison, and he'll be promptly turned around and sent back to his home country. So again, all this consternation was over someone who clearly could have been removed. And I'll just give a slight criticism of Trump. They didn't need to use the Alien Enemies Act. They could have deported this guy 5 ways. But I think Trump wants that as president. Again, like with the removal power, like with Birthright citizenship, he's trying to assert the powers of the presidency, and we have to deal with it. The third element of this is a case called AARP versus Trump. It's such a weird name. It's not the Association of Retired Professionals. People graduate before 2015, right? This is a guy, his initials were actually AARP. And what's kind of funny is there was another defendant, and his name was FGM. Do you know what that is? That's for female genital mutilation. Sorry, kids are here. Right, but so that's the other acronym. So bad acronyms all around. This is a crazy case. So this one arose in West Texas, kind of close to where I am. They were being detained in a facility called the Blue Bonnet Facility. It's actually the famous flower of Texas, the Blue Bonnets. And somehow the ACLU gets wind that maybe they might be removed. They're not really sure. So I want to give you the chronology, right? Around midnight, a TRO is filed. How many judges are checking your dockets at midnight? Do you sleep? You're allowed to sleep, right? So a TRO is filed a little bit after midnight. The judge gets to his office in the morning, around 8 or 9 a.m. He sees a TRO. He's like, okay, let me start working on it. The ACLU then files a motion for an emergency status conference. They want a status conference. And they say, if you do not grant our status conference, we will appeal to the Fifth Circuit. And they gave him 42 minutes to decide the case. 40 minutes to decide the case. You're all judges here. Can you decide a complicated case in 42 minutes? No. But the usual rule is you can't appeal to the lower court rules unless there's what's called a constructive denial, right? Has anyone ever actually had a constructive denial work? Does almost never work. Months can pass. Years can pass. They gave the guy 42 minutes. Judge Wes Hendricks is a good judge. I've known him for many years. So he didn't rule in 42 minutes. They took appeal to the Fifth Circuit. Fifth Circuit had it for several hours and were actually working on an opinion. They never bothered waiting for the Fifth Circuit to rule. They went right to the Supreme Court. And shortly after midnight, the Supreme Court issues an order. This went from the district court to the Supreme Court in 12 hours. I'm not exaggerating. John Roberts and Amy Coney Barrett and then Kavanaugh and Gorsuch should be ashamed of themselves. This was like the hammer to the knee. They just reflexive. They jumped over so many procedural hurdles to do this. Only Justice Thomas and Alito had the temerity to say no. They said, we'll issue a dissent later, because they didn't have time to write their dissent. By the way, this was Good Friday also. They were kind of busy on Good Friday. Maybe, I don't know. I'm sure the liberals weren't, but the conservatives were busy, I suppose. Meanwhile, the Fifth Circuit ruled I'm not joking, within a minute or two of the Supreme Court. Had the Supreme Court waited like 5 more minutes, they would have actually had a ruling to review. They were in such a hurry. And then even after the Fifth Circuit ruled, the Supreme Court sat up for like about a month. They chastised the judge for not deciding in 42 minutes, and they themselves took a month to decide it. Some chutzpah, huh? So just only a few weeks ago, the court decided the case about these people in Texas. And they said, well, you have to give them some process before you remove them, right? We won't talk about, the fact we have no jurisdiction. So look, I think what the court is saying here, at least in the Alien Enemies Act case, is you can remove these people, but give them some process first. That's not the end of the world, right? It's not terrible. But I think what that tells the lower court judges is that what they're doing is working. There's an active resistance against President Trump's administration, and the lower court judges are doing this. They are granting universal TROs, but they have no jurisdiction, clearly. Okay. Enough from the Alien Enemies Act. Let's go to Doge. Who knew what Doge was? People graduated before after 2015, probably, right? Doge was a meme coin, cryptocurrency, whatever. But Elon Musk, he's not in there anymore, right? So Elon Musk came to the government to become the head of Doge, the Department of Governmental Efficiency. Elon wasn't actually a appointed person in the government. He held what's positions called a special government employee, which you can only hold for about 120 days or so. And Doge set to work on cutting spending. And you may not know this, but almost every government grant can be terminated for convenience. That's the T for C, right? Terminated for convenience. It means the government can stop it anytime they want. And if you don't like it, you have a remedy, but it's limited. The remedy is you can bring a lawsuit in what's called the Court of Federal Claims. This is a court in Washington, D.C. It's an Article I court. And this is where you can bring suits for damages against the government. Why? Because the government waives sovereign immunity under the Tucker Act and the Little Tucker Act. These are statutes that give this court jurisdiction. You can't sue the federal government wherever you want because there's not been a waiver of sovereign immunity. So what happened when Trump cut $2 billion funding for U.S. aid? They ran to the federal court in D.C., not the Court of Federal Claims, the district court in D.C. And a judge, Judge Ali, a Biden appointee, ordered the repayment of $2 billion with a B, $2 billion of funds. The government said, Judge, we're not able to just process $2 billion right away. This is going to take some time to figure out all the logistics. And the judge says, I don't care. If you don't pay it by tomorrow, I'm holding you in contempt. I'm compressing a little bit, but that was basically the timeline. The case goes to the Supreme Court. And the court does something really weird. This is a John Roberts special, they call him. Johnny boy, what did John do? He said, we're going to deny the government's request. Right? The government said block the lower court order, we're denying the request. So usually when you deny a request, that's the end. You lose. What did Roberts say? Well, we're denying the request, but the lower court judge should clarify their ruling. The lower court judge should clarify what monies actually due. You can't do that. If you deny the request, that's it, it's over. You might grant it in part, you're allowed to do that. Like we grant this relief, not. But if you deny it, why? Because they want to be seen as ruling against Trump. We denied it. Headline New York Times, Supreme Court denies relief. They read like one sentence down, but they order the lower court to fix its ruling. They're playing fast and loose. They're trying to like manage things in this sort of Machiavellian sense, and it's not working because we see what they're doing. The court's prevarication, then you'll be idiots. Right? They think that you just read the headline and do nothing more. If you just read like one sentence down, you see what's going on. Another case, Department of Education versus California. So of course, again, when you cut funding, where do you go to a federal court in California? This was for $65 million for DEI grants, which were probably illegal under the Students of Fair Admissions decision, but Trump cut them anyway. Federal courts blocked the funding. By the way, California sued in Boston. Go make sense of that. Yeah, forum shopping just for the right. California sued in Boston because you're batting 1,000 there. It doesn't matter. Again, lower courts don't have jurisdiction. This is an issue with sovereign immunity. You have to have the Court of Federal Claims. So here, though, the court ruled in favor of the government. They said, well, you have to bring this suit in the Court of Federal Claims. Well, why did the U.S. aid case go one way and the education case go the other way? Ask Justice Barrett. I write about her a bit. I don't know how you reconcile these cases. I think she changed her mind. Or maybe she didn't know. I don't know. But this is correct. If you want to sue the government, go to the right court. You can't just go to federal court and sue the feds. All right. Category number 5. This involves firing of civil servants. So the general rule is if you are hired by the federal government, you have what's called a probationary period. I was a federal employee once. I went through this about a year or two where you're probationary. What does that mean? You have no civil service protection. You can be fired at will, right? No cause, fired at will. So what did Trump do on day one? He fired all the probation employees, just all of them. And these are all young people who were hired by the Biden administration, and they were probably aligned. Of course, a federal judge in San Francisco blocks their firing, right? And this is a case where usually in employment law, you don't get a TRO. Why? What's the remedy if you are unlawfully fired? Back pay, reinstatement, right? Any employment lawyers in the room? If you were improperly fired, the remedy is back pay, reinstatement, even you give credit for service, right? If there's tenure involved. But they granted a national TRO, reinstating with 16,000 probationary employees. Again, these judges are just making stuff up. They're making it up, right? There's nothing here. Oops. So the case goes to the Supreme Court, and here the Supreme Court issues an emphatically correct ruling. So anyone do work before the MSPB, right? The Merit System Protection Board. This is a federal agency that exists for workers who are fired and want to complain. You can't go to federal court to complain about a termination. There are civil service forums. So in a case called OPM, Office of Personnel Management versus the AFGE, the All Federal Governments Employee Union, the court said there's no standing here. Go away, right? This case doesn't belong in this court. Correct. Those are the 5 categories of case. I know I went through a lot, but let me try to bring it together and also time for Q&A as well. I think we're witnessing a very unusual time where we had an election. There were 2 very different choices that this country could make. The choices were stark. And people made their choice. And Trump won. But the courts haven't gotten that memo. And they are treating Trump as if he's not really the president. They're saying that he can't be trusted, that he doesn't get the usual presumption of regularity that the president gets, that he's abusing the office, that he can't be trusted. And a lot of these injunctions reflect that lack of trust. The Supreme Court, for its part, has been, if I had to grade it, I'd give it a C, right? They've gotten some of the big pictures right, but they've really failed to intervene early enough. They should have put a stop to this nationwide injunction like a decade ago, and they kept kicking the can down the road. At this point, there's no can. It's so warped. You can't see the can anymore. The court should have stopped this Alien Enemies Act stuff right away. They took months to settle it. The court should have stepped in right away on the doge issue and said, you can't issue orders unless you have jurisdiction. It took them months to do it. And maybe in fairness, the court is overwhelmed, right? Do you know how many cases the court decides a year? Like 50-something. If you're judging in the room, 50 cases in a year, and there are 9 of them. They were like 2 or 3 opinions each. It's crazy. But maybe they're overworked. Fine. But I don't know that they're quite rising to the moment that they're in. I think at least some of them, particularly the Chief Justice and Justice Barrett, see Trump as a threat. Right? I do think, if you look at, at the State of the Union, Trump came over to Roberts and shook his hand, and Roberts stormed her with a face, and Barrett went, gave him a face. I think that they're sort of overwhelmed, and they think that this is this sort of evil force. It's like a dictator. Look, Trump's going to win some cases, he'll lose some cases, but I think the court needs to be much more assertive. Just last week, I was testifying before the Senate Judiciary Committee on the issue of the national injunctions. If the court doesn't do something at national injunctions, every president, and this will happen to every president, will be hamstrung. He'll be unable to actually govern, right? The national injunctions basically become a veto by the courts, right? The president issues an order and the courts veto it, right? The framers rejected this notion of a council revision. We don't have that in our system, and it's extremely problematic that the courts have assumed this role. Now, what's left on the horizon for this term? Now, the court decided a big case yesterday involving transgender rights. This one went better than I perhaps expected. The only other sort of big case on the docket involving the separation of powers concerns the birthright citizenship case. And what the court might end up doing, which was sort of my inkling, is they might say, well, we're just going to argue this case to the merits in the fall. And the consequence of that is just dragging this on another year. So we might actually be in President Trump's third year of his administration by the time this is settled. Again, I think the court could do better, but I'll give it a gentleman's C. All right. I'm at 6:40. Let me stop here, leave some time for questions. Thank you all for your attention. All right, questions?
What do you think is going to happen on the citizens case?
On which one? Birthright citizenship? I don't think more than one or maybe two people will rule in favor of Trump on that one. I think it's going to be lopsided. The only difficult question is what to do with the national injunction issue, right? But, and I'll just pause here, if the court says you're allowed to certify a class of every legal alien in the country is pregnant, then it's effectively a national injunction, right? So the court might duck the national injunction issue, but make it that's very easy to get a national class, in which case it's effectively the same. And I don't think you can do that. Yes, sir?
Yes, this follows on that question. What do you think national injunction and some of these other questions is the right procedural way of doing this? Because it seems like either the court can rule and establish precedent, or I personally think would be better is the court could actually change procedural rules, or Congress could change procedural rules, and you could actually kind of restructure the way the system operates rather than have to have everybody interpret the precedent. But I wonder what your thoughts on that is, and what kind of reforms might happen. I know there have been some suggestions for how to change those rules to address it.
Right. So the asymmetry is this. In an ideal world, any judicial order would only run against the people before the court, right? Judges are never to limit themselves like that. Judges, sorry, think they're gods, especially trial judges, sorry, right? Judge Boasberg has like a god complex. He really thinks he'll save the world. The remedy, as James Madison would say, is ambition must counteract ambition. I propose to Congress the return of 3 judge panels. And 3 judge panels, I would do 2 circuit, 1 district. Any of you are on multi-member court, there is a reinforcement that comes with having 2 other people when it's not just you. Even if you don't all agree, you moderate each other. I think that's an important force. The second thing is I would impose timelines to get reviewed by the U.S. Supreme Court. If there's actually an injunction against the U.S. government imposing one of these 3 judge panels, mandatory review. Court's got to decide it within a few months. I'm not doing this thing where it's just for 2 years. The Supreme Court can't have its cake and eat it. If it wants discretionary jurisdiction for certiorari, it must take mandatory cases on an urgent basis. You can't have both. So I have a lot of ideas, and I was testing them before Congress last week. You know, the problem is this: when you have a Republican president, Democrats love the nationwide injunction. When you have a Democrat president, Republicans love the nationwide injunction. You gotta kill it for everyone. You can't have only one side benefit. You have to have both sides equally wounded. Good question. Yes, sir.
Do you think a nationwide injunction is a legitimate order that should be followed, and you just want to change the procedure by which they're entered, or do you think that a district court has no power to enjoin everyone across the country, and therefore it can just be ignored?
Look, there's a very deep academic debate about whether the Article 3 power allows an H1 injunction. So you have Sam Bray on one side saying you can't do it, Professor Neil Sohani on the other side saying you can't. I've kind of gone through this debate saying, I don't really know. I'm shrugging my shoulders. At this point, whether you can do it or not, Congress has the power to authorize relief against federal officials. Right? Whether actually the state universal injunction is trickier, right? So you have this in Florida all the time where, what's that judge with the immigration case in Miami? What's her name? Williams, yeah. She issued a statewide injunction against everyone in the state. That's not a thing. James Uthmeyer is correct. Your AG is correct. God bless him. He's correct. You can't issue injunctions in people who are not subject to your control. The ACLU only wrote a law saying it's certain was the sheriffs or the district attorney, I can't remember. She brought against certain officials, but not everyone. And the AG said, those people are not under my supervision, I can't authorize them. So under the federal context, I think Congress could bind all federal officials. Actually, that's not problematic. It's actually the state one that's trickier. But I think Congress should fix this. I think they need to. We used to have 3-judge panels, and now we don't anymore. Yes?
This may be a little far-fetched, but, with respect to the appointments, could the president simply announce the replacement, in effect, to kind of just change the locks? And say, if the president is allowed to tell us who the appointee is, just name someone. And obviously the other person is no longer in power.
Yeah.
And you sidestep the entire issue of whether they get fired.
So I'm going to answer your question in a minute. I'll give you an anecdote. Has anyone ever heard of the Department of Peace? It's this weird quasi-governmental agency. It's right on Constitution Avenue, right before you get to the JFK, the Kennedy Center.
Yeah.
Right? So basically Trump tried changing the locks on that one, right? He basically sent federal officials to this building to remove the incumbent officials, said, please leave, and they would not leave. He actually come back with D.C. police to escort them, saying, I represent the executive branch. You cannot be in this building. And they went to a federal court, and they tried to get a TRO to stop the changing of the locks. And a judge begrudgingly said, I don't think I can do this, but this is really bad. Give a good finger wag, the finger wag, right? So my point is, even if you try and change their locks on them, some judge will grant a TRO saying you can't do it. Unchange the locks. Release the hounds, right? Almost all the removal cases have been people seeking back pay. Because again, when you're fired, the remedy is back pay, not reinstatement to a federal position. Just to be clear, what that means is you're ordering the president to recognize the person you fired as the head of a department. Right? It's an order that runs against the president. There's an old case from Reconstruction called Mississippi v. Johnson. It's a case that says you cannot have orders running against the president. Maybe some ministerial stuff, but nothing substantive. So I appreciate your, I appreciate your question, but locking them out won't work. I also teach property, and it's the usual rule with tenant relations that when you lock them out, judges are unhappy. Right? They always want to go through the summer eviction, having the sheriff come along. They don't like changing locks. So
I'm just saying there is a new person that's running the department.
Yeah. This happened during the first Trump administration also. This was a crazy one. Her name was Lindy. What the heck was her name? Last name was English. So she was the deputy director at the CFPB, the Consumer Finance Protection Bureau. And the principal resigned, Caudry. And then Trump said, okay, I'm putting my guy in there to be the director. And she says, no, I'm actually the director. And this woman literally went to work, sat at a desk all day doing nothing. She's saying she was a director of the department. No one recognized her as a director of the department. She sat there at her desk doing nothing all day. I guess they could have changed the locks, but she wasn't doing anything. I don't think her email even worked. She just sat at her desk. Man, I should have read the newspaper. I don't even know. So again, people who are intent on making a political scene don't care about these things. Yes, sir.
You've been critical of Justice Barrett, but
that's an understatement. Yeah, that's an understatement.
So
yeah.
I'm curious about your opinion. Do you believe she is a conservative who happens to be an institutionalist, or do you believe she's taking the dreaded Souter leftward turn?
Yeah. So I said this. Barrett is not a Souter. I don't think she's an O'Connor. The problem is she's an academic. I'm a law professor, right? What do academics do? We don't actually do anything, right? We think about big ideas, and we take years to develop ideas. I'm an outlier, I lied, but she didn't write very much, right? I don't say that to criticize her. She just didn't do very much, right? She took years to think about one paper, and she thought about it, rethought about it, she refined it, tried to get perfect. She treats litigants as if she's grading a law school seminar paper. She wants a perfect, coherent thesis, a perfect thesis to explain everything. And if you can't bundle her a law review article, you're going to lose. She said this. She's chastised litigants who I respect profoundly, saying, you didn't think this through enough. Who the heck are you to say that? You've never litigated a case in your life. You know what you're doing, right? She was just an academic. I'm not sure she ever signed a brief in her life. Maybe she did, maybe once or twice as a junior associate, right? The problem with her, again, is not that she's drifting. That's the outlier. She just doesn't have a jurisprudential philosophy to start. She kind of just is an academic, and she thinks about things. Think about things, and let's not grant the abortion case. Let's have some more percolation, because Roe v. Wade is 50 years. That wasn't long. She wants to take her time. She denied Surgeon Dobbs. She didn't want to grant Scrimeti. They relisted Scrimeti 100 times because of her. Not 100, maybe a dozen times. When she finally gets to the end, she usually does the right thing, but she's very deliberative. She doesn't like granting relief to the emergency docket. Let's take our time. There are judges who are handcuffing the president. Get on with it. You have to rule. So again, I'm hopeful the decision just yesterday, Scrimeti, is a harbinger of good things to come. Her opinion has problems, by the way. It's actually really problematic. What's a suspect class? She says, well, if there's some group that they've been discriminating against for a long time, they're suspect. Okay, that would probably be gay people. Okay, so you're now saying gay legislation is suspect classification. Justice Kennedy didn't even say that, right? So again, she's law professoring again. It's actually a problem. So again, she's not a suitor. No, never said that. She's not a O'Connor. O'Connor actually had political skill. She was a Speaker of the House Legislature. She knew politics. Barrett doesn't. She hasn't done anything, and she kind of got elevated for no particular reason, and she's here. So again, I don't make this personal about her. I actually kind of like her as a person. I think she's a wonderful mom. I think she's a very good professor. Her students loved her. But as Supreme Court Justice, we could have done so much better. So much better. Yeah. Jeopardy champion. Let's hear it. He was on Jeopardy.
Nobody knew that.
Now they know.
That leads to my question, which is, obviously the president has referred to the Federalist Society with great critical terms that have all been referred to as sleazebag.
Sleazebag, yeah.
Quote unquote. So maybe, if there is a Supreme Court vacancy, he might take a little bit of a different approach. He might call Mike Davis. Maybe hopefully he'll call you.
No one's called me. No one's calling me.
What does a Trump 2.0 justice look like?
Well, I kind of joked, maybe pick a senator. I'm being totally serious. Like FDR, I'm not joking. He wanted, I'm quoting, he said, he wanted a thumping evangelical New Dealer. He picked Hugo Black, who was one of the ardent senators in supporting the New Deal agenda, senator from Alabama, who had been literally a traffic court judge, exaggeratingly. He had never done much law. Member of the Klan, that's a good qualification, but he basically had no legal practice, but he was a senator. I don't know, maybe pick a senator. Ted Cruz would be good. Josh Hawley would be good. Eric Schmidt from Missouri. There's lots of options. In terms of judges, I know he likes Judge Cannon from down the road. I argued for her last summer. I'd be fine with that pick. I think what she has, and what some of the Trump judges have, is what I call courage. It's a phrase people don't like when I say it, but it's true. It's, can you resist the temptations? Are you going to be susceptible to the, too many nationwide injunctions? Okay, well, stop granting those. You have to be able to ignore people who want to destroy you. It's something I do a lot. I get attacked a lot. I don't read any of my social media comments. Don't read them. Don't care. You have to be able to just put yourself aside from that and be out of this DC cesspool bubble. I like Judge Ho very much. I think he'd be an excellent judge. I've gotten to know him well. He doesn't blink when he gets pressure in front of him. But there are lots of people he can pick. The bench is deep. The problem is with Barrett, people said, trust us, she'll be good. And with Kavanaugh, he had a record before him. People just wanted to look the other way. I'll give Kavanaugh the benefit of the doubt. We needed him to get Kennedy off the court. It's like a pawn. I'll make that sacrifice, right? And Kavanaugh's been actually pretty decent the last 2 years. So, finger crossed. But so far, so good. Gorsuch, it didn't need to be him. There was no need for it to be him. But again, he's mostly good. His Bostock ruling, I think he regrets that. He did not ask a single question in his committee arguments. It is now shut. And apparently yesterday when Sotomayor was reading her dissent, he kind of just looked at her. It's like, Neil, where are you at? Right? So I think he realizes that was a mistake, and he's not going to do that one again, I think. But yeah, there we are. And I don't think, to anticipate a question, I'm not expecting vacancies this year, maybe next year, but I don't think we'll get anything this year. All right, what other questions we have? Oh, I'm sorry, this side, yes. My head didn't pivot.
No worries. So the
Bye,
question
boys.
is, if we have all of these nationwide injunctions, if we have the Supreme Court is essentially ignoring procedure and issuing nationwide injunctions and overruling the president, do we actually have a constitutional republic anymore? Because remains the case.
I get all these questions. Is Trump a dictator? Right? And what's the definition of a dictator? A person who exercises powers they lack. Right? And during the first Trump impeachment, we talked about abuse of power. Right? That's what they got Trump for, abuse of power. You didn't commit any actual crime. It's an abuse of power. Well, if an executive can abuse his power, can a judge abuse his power? Right? Can it be a judicial abuse of power? And I know the Chief Justice says, we can't impeach judges. No. I don't think we should be impeaching judges, but is there such thing as an abuse of judicial power? Right? Are some judges behaving in such an egregious fashion that they're transcending their bounds? They're issuing rulings against the president that go nationwide. Now, I agree with the Chief Justice that the remedy to bad district court judges is the appellate process. But that depends on the Supreme Court engaging in appellate review. If they turn things away to give these half measures, they say, we're just not going to sit in it for a month, right? And the president's first 90 days were basically hamstrung by the courts. The Supreme Court didn't really do very much. So, again, we always say, Trump's the dictator and Trump's going to destroy the republic. The other branches share some blame in this as well. They're not blameless. I think the court has responsibility. This is only, month 5 of the Trump. We've got 3.5 years to go. Who the heck knows? I mean, if looking at if there's a change in the House of Representatives, what if third impeachment? They'll just impeach him over and over and over again until they find something, right? Until something sticks. Presidents can't govern anymore. I think that's what we're sort of left with. What other questions we have?
One more minute.
Oh yeah, over there. Go ahead.
If you've been following what's going on with Judge Newman at the federal circuit, do you think she's being unconstitutionally removed?
I'm not just. I was with her this week.
Were you really?
Yeah. So on Tuesday, I do lots of things. So I had a good week. So on Monday, where was I? I was in the Bible Museum. I'm part of the President's Religious Liberty Commission, and I was testifying about religious liberty. On Tuesday, we had a House of Representatives briefing. Oh, this isn't public yet. Now it's public. A House of Representatives briefing on Judge Newman, and I was with her. So who's Judge Newman? She is a 97-year-old federal judge, a Reagan appointee. Brilliant. She has a PhD in chemistry. Who the here can have a PhD in chemistry and be a lawyer? She was appointed by Reagan to the federal circuit when the court began in 1984. Basically, I was born in 84, so basically my entire life. Right, so you think of 2015. There's like 1915, right? This is a person who was born a long time ago. She's almost 100 years old. Her chief judge accused her of having mental incapacity issues, and stopped assigning her new cases. She's an Article 3 judge. She's basically been impeached, and this has been going on for 2 years. John Roberts has not lifted a finger to help her. She's gone through relief in federal court. The federal courts have not helped her. They're waiting for this woman to die. And the argument is that she's incoherent. Let me tell you something. I sat with her for an hour. She's more lucid than I am. Not a single or but, what. She's so coherent, remembering facts and details. I said, I'm from Houston. She said, oh yeah, my clerk from 2009 is from Houston. Go say hi to her. People can't remember their grandchildren's name at 97 years old. And she knows everything perfectly. She's a remarkable person. I hope the House was hearing about her. Hope they subpoena the chief judge, and John Roberts might get off his butt and do something. It's really egregious. Woman's being impeached. They're waiting for her to die, and she will not step down. So good for Judge Newman. You done? We're done. Yeah. Thank you all so much. Thank you.
All right, I think we have upcoming couple more announcements. August 14th.